Okay, our next speaker may also be a familiar name to a lot of you. Barb Butler, the president of Barb Butler and Associates, has worked in the area of alcohol and drug policy development since starting her business in 1989. She's been there for a long, long time. She's worked with many industry sectors across the country, probably all of your companies over here. The list is long, but it includes all modes of transportation, certainly utilities, healthcare, oil and gas, manufacturing, construction, mining, just to name a few. Barb has also been directly involved in numerous hearings as the overall Canadian direction on drug testing has changed over the years. So she continues to be involved in A&D policy development and implementation, ensures that organizations have the right customized information, and also is involved in training a lot of those people. So she's going to be talking about reviewing and updating your company alcohol and drug policy. Please help me welcome Barb to the stage.
Hi, everyone. Hard act to follow. Melissa's amazing. But anyway, are my slides up? Okay, great. So just want to give you an update. I've been dealing with this issue for over 30 years and still have new companies, even yesterday and the day before, coming and saying we want help with the policy. So it's still a current issue for so many companies. And so what I want to do is just give you a little bit of background on what's going on right now, and Melissa's covered a lot of it to do with cannabis. I want to discuss some of the key elements in a workplace policy, because I am getting some policies sent to me and I'm going, wait a minute, we're missing things, like we need to cover a lot. The areas for update, consideration, and of course a little bit around testing, which Melissa's also talked about. So we've got a lot of drugs out there. Some of these are legal, some of these are illegal, some of them are there because of the work that we do, where people will breathe in cleaning supplies or whatever just to get high. So there's a lot out there, and our biggest issue is it can all impact performance, and so we need to be aware that there's a broad scope of what's out there that can impact. They may be used for medical reasons, very legitimate. For recreational purposes, people may want to use them to get high or euphoria, whatever. Some people, and particularly perhaps in the last few years, may start using them to escape from reality. They've got anxiety, depression, there's issues going on that they may turn to these drugs, and I think we're going to find out a lot more in terms of how much use patterns have adjusted during this pandemic. And some people turn to them to deal with withdrawal symptoms. They're withdrawing from one drug, they may turn to more of it, or they may turn to another drug to help them deal. So the bottom line is we want to focus in our workplaces around fitness for work and responsible use when allowed, and being very clear on what those expectations, requirements are. So we've got these guys that they only have one drink at lunch, but think they're just fine. And we want to be really clear about whether people can drink at lunch, because what we've got is even 5 ounces of what is it, 12 ounce and a half of spirits, 5 ounces of wine, and 12 ounces of beer. All of them are considered a standard drink, and they can increase someone's blood alcohol level by 0.02, and it can take just over an hour to get that back to zero. So those guys drinking, it's going to take a while to get that back to zero. So I'll get into this a little bit further, but as a result, we're not using in workplace policies the 08 of the criminal code with respect to driving. The policies are very clear. If it's 04 or above, that is considered a positive. And the majority of companies are now saying even 02 to 039, there's a safety risk. Someone is still under the influence, and so therefore we will remove them from work, and they may be subject to progressive discipline, whatever. We just can't take the risk at those higher levels. If our rule is do not report under the influence, and someone tests at above 04, at 04 or above, that's a positive, and there's consequences. But even at the lower levels, there's still concerns. And the breath analyzers are accurate at the 0.2, and so that's what the testing programs are at. So we've got all sorts of drugs out there. Cocaine, people can be reckless. They'll take risks that they wouldn't take. Methamphetamine, cheap, easy to make, whatever, highly addictive, and can have impacts as well. Ecstasy, MDMA, all of these are tested under the testing slate, can have after effects that can last a long period of time. And then, of course, many other drugs are out there that can impact people and cause them to get high. So we're also concerned, Melissa talked about medications, we're concerned that medications can impact a wide range of skills as well, even when used as directed. So we need our policies to be very clear on responsible use of medications so people are still fit for work. And what we've found is more and more opioids have been prescribed, as everyone knows. People were getting paid to prescribe a lot of opioids. And so they're as well increasingly used illegally. And then can lead to addiction, as we've learned. And people are switching to fentanyl in many communities. They're switching to W18 carfentanil, which are much stronger drugs, and they're out there. So we just need to be aware that there's a lot of medications that even when used properly can still be a safety risk. And then, of course, cannabis, as Melissa said, is even for medical purposes, can still negatively impact performance at work. And just to reinforce again, it's not prescribed, it's authorized, it does not have a DIN, it's not prescribed, and it's no longer a situation where people are seriously ill that are getting it for whatever effects they can get. It doesn't cure anything, as she explained. So we've got a person in pain. Can you give me some medical marijuana? No, we're against it. It leads to unintended consequences. I'm prescribing opioids, OxyContin instead. And that's what has been happening. So anyway, current situation, as Melissa said, legalization, recreational use was legal in 2018, not to be political, but it was part of a political campaign to get elected, and therefore we've got it legal. You can possess or transfer 30 grams, and that little picture there shows you what 30 grams would look like. People can grow 4 plants from legally obtained seeds. I just came down from my cottage. I could grow 100. No one would have a clue. Like, no one's checking this stuff. Like, it's just, anyway, people can make products at home so they can put it in food and drinks, and people can consume locally when allowed. When our current premier got elected, he changed the rules, and anywhere you can smoke a cigarette, you can smoke cannabis. That's a deal. So nothing in the legislation deals with workplace issues, and we had just a whole team of companies, corporations, whatever, hammering the government when this was coming through to say, listen, give us more flexibility in terms of what we can do with respect to workplace safety. And Garneau, who was the transportation minister at the time, said, no, it's up to you. Deal with workplace safety. We're not going to get involved. We're just going to make it legal. So as a result, companies across the country, and I moved into the million-mile category with Air Canada because I was helping deal with this across the country, updated their policies to make it clear that cannabis in any form is still a mood-altering substance and can impact workplace safety. So we have to be very clear in our policies on exactly what our expectations are. So, because whether it's used legally, medically, whatever, it still reduces short-term memory, alters sense of time, affects people's concentration, their ability to react swiftly to something is dulled, and so we've still got concerns. We know that there's significant psychomotor impairment, and we know that crash risk increases if cannabis is combined with alcohol, and we do have studies that confirm that. So we're concerned about that. And of course, as Melissa said, the potency, they've learned how to clone the plant to get the THC levels higher and higher. And so as a result, many of the studies about the impacts of cannabis on safety, on driving capability, et cetera, were at 3.5 to 5% THC. And now Health Canada can issue 30% THC in their oils, in their dried plants, et cetera. So it's a much more potent product than it was in the early days when all these studies were done. And the more complex the task, the longer the negative impacts can last. So as Melissa said, OMAC advised the full extent of prolonged exposure. We don't know. But impairment can last 24 hours or longer, and we need more studies on the higher potency to see exactly what that's going to do. So getting back to the broader situation, impacts can be on motor skills, on concentration, reaction time, but also on decision-making, memory, planning, problem-solving. And so that's why company policies from the beginning, I got dragged into this with the transportation sector and then after the Exxon Valdez incident, and we just said from the beginning, the policy should apply to everybody. Everyone should be fit for work, because even those that are making decisions, their use could impact safe operations and et cetera. And so the impacts can be even at low levels, as with the alcohol that I discussed, and at the higher doses, the effects can be more significant, and of course, there's withdrawal effects that we have to deal with. And in the workplace, we can have increased accidents, absenteeism, compensation costs, et cetera, but we can also have corporate culture, the morale of the work team that has somebody showing up unfit regularly and they don't know what to do about it, so their morale can be impacted. And of course, the loss of productivity, low quality services, et cetera, all of them can be impacted. And so that's why companies have said, no, we want to have a clear policy so that everybody knows what's expected. So employers need to have clear rules around fitness for work, addressing all drugs, including recreational cannabis, have a procedure in place if they become aware that someone has clearance to use. And DriverCheck developed a procedure that helps companies address this to determine, are they using legally? Are they accessing it legally? Should they be using something else? Because it's really not a medical solution necessarily, and it can create fitness for work problems. We should be clear on when alcohol can be used in conjunction with work, if at all, not those guys going and having a drink at lunch and then coming back to work. And we want to reinforce responsible use of medications so that, and again, the expectations around fitness for work. So how comprehensive policy that's very clear, well communicated, and enforced throughout so that employees have proper communication and supervisors, managers have proper training so that they know what's expected. Just really briefly, because you'll get more on the legal side of things, but there's a variety of legal implications that have caused companies to put programs in place. There's negligence liability, there's driver liability. If someone's operating a company vehicle, even on personal time, there can still be liabilities for the company. We've got hosting responsibilities. You have an event, people are drinking, and then they get in a vehicle and drive and cause a crash. There can be liabilities for the company. We've got occupational health and safety. Due diligence applies not just to employees, but also to contract workers. We've had rulings that have said the employer still needs to ensure that those contract workers are operating safely. And then the criminal code, where there might be willful disregard for safety. And there was a major case some years back, Metron Construction, where they had not taken proper responsibility for people on a high level, working at a high level, and they weren't properly tied off. And the thing fell, someone was killed, there was a lot of issues there, and they were found criminally liable for failure to take all responsible steps for safety. So that would not just include that kind of the safety harness, et cetera, but that would include making sure people are fit for work. So employers and their representatives, the frontline supervisors, need to ensure they act responsibly and minimize the risk of accidents or incidents. Then we've got human rights. you can't discriminate on the basis of a disability or handicap. And current or former alcohol or drug dependents are considered a disability. However, we have had rulings that have said casual use is not protected. You still have the right to be very clear on what your rules are and enforce those. So we do need to provide reasonable accommodation up to undue hardship where there's a dependency on alcohol or other drugs. But we want to make sure that people are not acting on the perception of a disability, because that can also be seen as a human rights issue. So what we're always telling supervisors, deal with someone who's unfit for work and address the issue. Do not diagnose. Do not try and come to the conclusion, oh, we must have a drug problem. We're not doing that. We're just dealing with, are they fit for work, and addressing the situation, and not diagnosing. So human rights and safety, this has become interesting, because the criminal code says you need to take all responsible steps as an employer to ensure safety. So to knowingly let someone do safety-sensitive work while using a drug or medication that can impair them, that could lead to criminal liability. So this whole thing about medical cannabis and what we're going to allow, we've got to be really careful about that. BC Court of Appeal ruled that human rights is important, but it does not override your obligations around safety. So that was a real key. I was involved in that case. That was a real key case. And the Alberta Court of Appeal ruled that extending human rights protections to situations resulting where placing the lives of others at risk flies in the face of logic. So that was a very key ruling as well, telling you, yes, you can take all responsible steps for safety. So Canadian legal direction now says, and has said, you don't need proof of a problem before you take steps to put in place proper workplace policies and enforce them. So finding a balance. In the early days, an Imperial Oil ruling at the Ontario Court of Appeal, and again, I was a witness for that, if someone tests positive and has a dependency, there's a duty to accommodate. So that's what the court came out with. However, Elk Valley Coal, key issue, and I went to the Supreme Court for this one, this was key. A worker caused an accident, tested positive for cocaine, and his employment was terminated. After the fact, he claimed he had a dependency, and he said the termination was discriminatory. So it went through arbitration, the courts, et cetera. Alberta Human Rights Tribunal said no discrimination. He was fired for a policy violation. You can't just claim a problem after the fact. And then it went up through to the Court of Appeal, and the Court of Appeal in Alberta said he had every opportunity to get help before he caused the accident. And so that's why the prevention components of your policy are very clear. It needs to be clear on how someone can get help, what they can do if they reach out, et cetera. And then the Supreme Court, which I said I went to, said that was not unreasonable, and the termination was upheld. So we've got one court saying test positive, duty to accommodate if they have a dependency, and we've got another court saying no, not necessarily. So we've got two issues that we need to, so this doesn't guarantee that if someone tests positive, no matter what, you fire them. But it does say if it's serious enough that you feel under your policy termination is appropriate, we've got a Supreme Court ruling that says that's fine, as long as your prevention components are clear. So trends in policy development, many employers in recent years are developing comprehensive policies. I had two get in touch with me in the last couple of days who didn't have anything in place that want to put something in place. So like people are realizing they need to make this clear. They're concerned about use patterns. There's incidents on the job that they feel they need to start addressing. They need to address contractor compliance. They can't just turn a blind eye with respect to contractors. And increased concern, obviously, about medical and recreational cannabis use. Most activity has been in higher risk, as Dr. David said. Oil and gas, forestry, mining, construction, manufacturing, warehousing, utilities have all been very active on this, but increasingly municipalities, healthcare, certain retail are moving in, And all aspects of transportation have put in place programs, including transit, and you'll hear more from Peter a little bit later with TTC. And they're including testing in policies that also reinforce access to assistance so people know they can get help before they have a violation. So, oh, okay, supervisor training moved over, but anyway, so the policies need a balance. They've got awareness and education. We've got access to assistance through employee assistance programs, but also assessment through substance abuse professionals, which is key. We've got training for supervisors. It's key. They need to know what steps they need to take and how they address situations if someone appears unfit or is involved in a serious incident. And we need tools to investigate a possible violation. And not just testing, there's other tools that are involved. So we need to balance the prevention, and this is where things are so different in the States. I get policies from the States, and people want to apply them to their Canadian operations. I can't find anything on prevention. Like, it just doesn't exist, because that wasn't part of the US DOT testing requirements. They just didn't mention prevention. But in Canada, we need to be very clear. We need processes to prevent problems, we need assistance for people that may need help for a problem, and we need monitoring and support for those that go to treatment and are coming back. We need to monitor and have some kind of ongoing support system for them, because relapse is a function of that disease. But we've also got deterrence components. We need to communicate our rules, our standards, and expectations. We need to reinforce the investigative tools and use them, so that people know if they show up under the influence, there will be investigations and consequences. So we do have clear consequences to reinforce the importance of compliance and getting help before those consequences kick in. And that's what Elk Valley really reinforced. I was so happy that that came out. So the policies need to have clear direction on your objectives, your application, and individual responsibilities. They need to set rules around alcohol, illicit drugs, and mood-altering substances, and cannabis falls into the mood-altering substance category. Responsible use of medications, and how you want to deal with on-call or unexpected call-in situations. People need to be clear. If they've been drinking and they get called in unexpectedly, they need to decline that call-in. And if they're officially on call, they need to still be in compliance with the rules. We need to clarify, again, the prevention side, access to assistance, direction on assessments, and have return to duty programs. We need a range of investigative tools dealing with unfit investigations, impaired driving, searches if there's grounds to believe someone's in possession of a banned substance or product, as well as the testing component. We need to clarify so people know there are consequences for crossing the line, and be clear on what those are and what conditions there would be for continued employment. And normally that would be a program of unannounced testing for a certain period of time because they crossed the line and you're giving them another chance, but there's something set out in an agreement with them and here's the rules. And we want clear communications to all employees and training for supervisors, managers, so that they know exactly what their responsibilities are. We need employee assistance programs, confidential counseling service for any personal issue, not just alcohol or drugs. And normally it's voluntary, but supervisors can suggest a referral. But then we've got the substance abuse professionals. That's a different line. If someone comes forward and says, I think I need help with a problem, we're not sending them to the confidential EFAP or EAP because we don't know then if they go or not or what they do. So once the company has knowledge that there's a potential that someone may have an alcohol or drug issue, that's a SAP assessment. And we need to be clear in the policy that they need to go and they need to follow through with whatever results, whatever recommendations come from that assessment. So I just literally reviewed a policy for a major transportation organization where if somebody came forward to their supervisor and said, I may need help with an alcohol problem, they would have them go to the EFAP. And I'm telling them, no, if you have knowledge, EFAP's confidential. They need to go for a SAP assessment, and you make those arrangements. So they're two separate and distinct routes that we need to follow. But the key is that the employee knows where they can get help as a result of Elk Valley. So overall, most of the cases that we've had have, and Melissa's been involved in a lot of them as well, they've focused on when, how, and who gets tested. We had a policy arbitration I was involved in way back with CN, and the arbitrators said you do not need to wait for a serious incident to introduce your comprehensive policy. There's no requirement for bargaining with the union. The company has the right to put the program in place. And we've had various rulings that have stressed the balance between prevention and deterrence, and that's the Canadian approach, that we've got the balance for both. Our legal environment is significantly different than in the US. You can't just import a US policy. It just doesn't work. They're focused on testing. We're focused on the balance. And they can't start testing without a broader policy. In Canada, that's the approach we've had. So we want to also make sure that your policy reflects your operational requirements, because different companies are going to have different requirements, and so we need to make sure it makes sense for your program. So for updating, you should be reviewing your policy every 2 to 3 years. That's become pretty standard because there's going to be changes in use patterns, which we're going to learn from this pandemic. There's changes in drug availability. There's way more opioids, et cetera, that are out there available. And of course, we've had the cannabis legalization. There's also legal decisions that may come out that may cause you to need to adjust slightly your approach or even toughen it, because the legal decision says, yeah, you can do this, so toughen it. The company's own experience, they may have incidents, et cetera, that you say, hey, we need to be clearer on what's required. And the key is that any new policy or any updated policy, we make sure it's well communicated, and that frontline management and supervisors have training supported with appropriate procedures, and there should be a record of your communication, and there should be a record of your training, so that that's really clear. Increasingly, companies are adding reference to mood-altering substances with the illicit drug rules, and defining this to include cannabis in any form. Oral, creams, smoked, et cetera, the prohibitions still apply. So what I've been adding to policies right in the illicit drugs and mood-altering substances, for purposes of this policy, cannabis is a mood-altering substance, and these prohibitions still apply. So people cannot get away with claiming medical use and operating a tractor trailer or whatever. Parallel with the original DOT regs, I mentioned earlier, the cutoff levels. Alcohol cutoff, they set out and applies to all of our cross-border transportation at 0.4 above is considered a positive, but for safety reasons, people at 0.2 to 0.39 are pulled and from until safe to return, usually their next shift, but there could be progressive discipline. Someone tests at 0.3, 5 hours into their shift, how much were had they drank before they came on, or were they drinking during the day? So there still needs to be certain consequences and action for safety. And we're reinforcing, over again, we really had to do this when medical cannabis became more used, responsible use of medications. Make sure they're responsible to tell their doctor what their job is, because what we were finding in those pot shops when people would go on Skype in order to get it to sleep at night or whatever, they weren't telling the doctor that they worked underground or drove a transport trailer or whatever. Like, they were just saying, oh, I need it, I can't sleep at night. So we're making it very clear in the policies that they must ensure their doctor knows the nature of their work and that they use a safe alternative, because there will always be a safer alternative for whatever medical condition they're claiming. And any need for modified work would be confirmed with their doctor, that the company reserves the right to confirm that, and make sure the doctor knows this is what the person does. And I've had a few occasions in the early days with medical cannabis where the doctor said, well, I didn't know he worked underground. No, he can use this instead. So again, prevention, reinforced by Elk Valley, make sure it's clear the options. They can take to get assistance for personal issues, including those associated with alcohol and drugs. We want to differentiate, again, between the confidential EAP and the mandatory referral for a SAP assessment. The consequences section needs to be clear, so everyone, I've started adding this in policies, that right in the consequences, everyone is required to be in compliance with this policy, even if they have a current or emerging dependency, so that it's very clear and it reinforces the Elk Valley ruling. And we want to communicate, again, and have a record of the communications. Investigations, we want to, if there's clear rules around fitness for work and rules around use, possession, et cetera, we need to have investigative tools. And if the company's prohibited possession, they need to have a capability to investigate possible concerns. If someone's driving a company vehicle or driving on personal time on company business and they're charged with an impaired driving or get a provincial license suspension, that's still a reasonable cause test. It just happened to be through the police. So they need to report, and there needs to be consequences for driving under the influence and getting that impaired charge or sanction. And if someone appears unfit on the job, or if someone is directly involved in a serious incident, testing would be part of the investigation. Now, one thing I wanted to mention, I had one of my clients that had, in the early days of the pandemic, 600 people working remotely. And they had a Teams meeting, and somebody appeared quite drunk on the meeting, and they got in touch and they said, what should we do? And I'm kind of going, well, I don't think we're going to have a DriverCheck collector go into their home. It's the pandemic. And they wondered if one of their security officers could go and pick the person up and take them to a collection site. And we're kind of going, well, that's not fair to the security guy. And so anyway, we came up with a process that more and more companies are including now in their policies to deal with remote work. They're defining remote work, they're ensuring it's clear that the rules apply even when someone's working remotely. There's procedures to address a situation if someone appears unfit. It could be a medical reason, it could be other issues, so we can't just jump to the conclusion that they're impaired or under the influence. But they also, should there be declining performance or should this happen, they reserve the right to remove someone's remote work status, because you just can't take the risk, and then they're in a position that they can monitor what's going on. I wanted to mention contractors as well. I recommend strongly they not be covered under the employee policy. They should be a separate statement of requirements for the contractors, because the potential could be that a worker who tests positive and is removed from the site could go running to claim a problem and expect to be accommodated if you've got them under the employee policy, because the employee policy has prevention components, and so we don't want to take that risk. So what we've been doing, even right since Imperial Oil and Exxon Valdez back in 1989 or whenever we did that, we've got a separate statement of requirements for contractors. We do not put them under the employee policy. So it's very clear on what the rules are, the investigative procedures, and the consequences. We're silent on prevention, up to their company. It's not your responsibility. But I'm still seeing policies that the contractors are put under the employee policy. Don't do that. Like, just keep them separate so that you don't run that risk. Syncrude, we had them separate at Syncrude, and a contract worker tested positive and went running to Alberta Human Rights because they were removing him from the site and claimed he had a problem. And they said, no, this is your program. This is not Syncrude's. You're not under Syncrude's policy. And so we wanted to make sure that the two were separate, and so that worked. So Melissa's talked about testing. I just wanted to reinforce that it's certainly can be part of a program in Canada, but without a policy around it, it's not defensible. And a testing program alone is not defensible or necessarily effective. You want a comprehensive policy with all of those 4 elements that includes testing, and yes, that's been upheld many cases that we've had. But assessment and accommodation may be required for someone who's positive and has a dependency, and that's still a balance that we have to deal with between the Ontario Court of Appeal ruling and the Elk Valley ruling, and so we've got two different directions, and so we just have to keep that in mind. So companies need to be well aware of what's involved in testing. You need to be very clear on who's subject to testing, under what circumstances, for what substances, using what technology, and Melissa's talked to you about the technology, and what to do with a positive or a refusal. So you need to be very clear on what a refusal to test is. And I've been adding a definition on that and expanding it every time something new comes up. And trying to cheat on the test, obviously, is a refusal to test. And there was a conference, I don't know, Melissa, if you know about this, but there was a conference that somebody told me about, that someone was up like me, talking away about all of this, and then pulled a little sack of clean oral fluid out of her mouth and said that this is a way you could still beat the oral fluid test, having a little thing in your mouth. Yeah, I just, okay. So it's better than the urine testing because you still observed, but I know. So you need to decide when you're going to trigger testing. Applicant testing, we've had rulings that have said it's got to be limited to safety-sensitive positions, final qualification step. It can't be the only step for a safety-sensitive position. It could be existing employees going to a safety-sensitive position, so that could be testing. We've got pre-access before going on certain sites, higher-risk sites, and a lot of employers are requiring contractors to do pre-access testing before they go on a site. We've got investigative circumstances after a serious incident, accident, or a near miss, and near miss has been upheld. We had a major ATCO ruling that a near miss was upheld in an arbitration, so we're building that in. With cause to believe someone's under the influence, on return to duty after treatment or after a policy violation, the person needs to pass a test to get back on the job, or as part of a post-treatment monitoring program to support their ongoing recovery. But we've also got deterrence situations unannounced as a condition of continued employment, and potentially random testing, and I'll talk about that. So the drugs tested, we've got the 04, but also a decision on whether you want to take action at 02 to 039. For the alcohol side, there's a core drug slate, and the opioids, there's an expanded slate that includes OxyContin, hydrocodone, expanded slate, and you need to make a decision on whether to include other drugs, but there's a core slate that's part of the program. You want to obviously have a very qualified third-party administrator so that you make decisions on when testing is appropriate for your organization. You use trained collection agents, calibrated breath analyzer for alcohol testing, and there's a conforming products list that the U.S. government set out, and so that's what we rely on because we know they're accurate at 02. We've got a decision on whether you're using urine or oral fluid or a combination, and whether quick urine testing will be used. More and more people are using it in reasonable cause and post-incident situations, and then if it's non-negative for cannabis, they're doing oral fluid, and that's what goes to the lab. So that's become more and more of a trend. And of course, you've got the independent medical review of the lab results, which is very keen, and the chain of custody, unbroken chain of custody. So you want to make sure you're using qualified people, and I expect everybody, because they're here, they're working with DriverCheck, you know you've got qualified people that are providing your program. You need to be clear on the consequences for a positive test. You need to be clear on what refusal to test involves, including confirmed tampering or failure to go for a medical assessment, shy lung, shy bladder. And you need to deal with dilute situations because people will, as Melissa said, try and drink enough fluid to get under the cutoff level. And so you need to have a procedure for whether that happens for a current employee or whether that happens for an applicant, what you're going to do with a dilute. Just quickly, there's no federal or provincial laws that specifically prohibit or allow for testing. I just read a policy that said the cutoff levels approved by the Government of Canada, and I'm going, no, Government of Canada hasn't done anything. Like, this is, yep. So there's no direction provided by any government body, but reasonable cause and post-incident are allowed as long as it's part of the process of investigation. And applicant testing has to be limited to safety-sensitive positions. Return to duty follow-up monitoring acceptable under an agreement with the employee. And random testing has to be limited to safety-sensitive positions, may be acceptable under certain situations under human rights. Imperial Oil was upheld for random alcohol. So it just depends. But in a union setting, reasonable cause and post-incident was upheld in the CN case for safety-sensitive positions only, or in a safety-sensitive operating environment. But more and more, I'm having unions say to me, why isn't it the same for everybody? And so more and more policies are applying to everybody, not just testing for safety-sensitive positions. There's no requirement for reasonable cause in a serious incident. It's only those individuals whose acts or omissions contributed that would be subject to testing, but you do not need reasonable cause. And I see too many programs where they require reasonable cause in a post-incident. No, you don't. It's the seriousness of the incident and whose acts or omissions contributed. That's what makes the difference, because everyone recognizes it's hard at the best of times to tell if someone's under the influence, but after a serious incident, it's going to be even more difficult. So less serious situation, though, you would need reasonable cause. And random testing, we've had a series of rulings that concluded to introduce random testing in a union setting only for safety sensitive. You must have evidence of a problem and prior union agreement. And so this was confirmed by the Supreme Court of Canada in the Irving ruling, and I was involved in that one as well, that they need proof of a problem. They didn't make it clear what that looks like. And so Suncor went through all sorts of court cases in order to figure out, and they finally got union agreement for their Northern Alberta operations to put in the random testing. I have many companies that are building their case for introducing random testing, but we just don't know what the line will be for what that case is. Anyway, so it's becoming a standard part of programs, safety-sensitive, risk-sensitive work environment, reasonable cause post-incident accepted, applicant testing for safety-sensitive, random testing for some operations, but again, you need proof of a problem if you're a union operation. So resulting policies, each policy is going to be different depending on your corporate culture and values, depending on the fundamental aspects of your business operations, regulatory environment, obviously cross-border is affected, specific program needs will differ from one company to the next, and stakeholder needs and expectations may differ. So policies, your policy's not going to be identical to the next one, but it's going to have the key components that I've discussed. So anyway, I've probably gone over. I apologize. I started late.